Hello classmates, my name is Tina Gote and this is my discussion post for terms and conditions of teacher employment. Just to give background on the case or the scenario that we're discussing, Mr. Myers was a physical education teacher at Simpson Waverly School in Hartford, Connecticut, employed since 1998. His 5-year teaching certificate expired on October 24th of 2013. He was placed on paid administrative leave on May 7th of 2013 due to a DCF investigation regarding an alleged physical abuse and neglect complaint. DCF investigated and substantiated the complaint in August of 2013, and on September 12, 2013, Mr. Myers was informed that his termination was under consideration. Mr. Myers was reminded to renew his teaching certification with notice between January and September of 2013. He claimed to have submitted his renewal but failed to complete the required paperwork on time. The Connecticut State Department of Education requires applications for renewal to be completed before expiration date, and postmarks do not count. On October 25th of 2013, Mr. Myers was terminated by the district due to an expired certificate. On October 30th of 2013, he finally submitted the required application form, but his certification had already lapsed. In this case, Mr. Myers' scenario versus Hartford Public School, Mr. Myers seeks to challenge his termination and argues that his dismissal was improper due to the status of his certification renewal process. Legal question was, is Mr. Myers' termination lawful given that his teacher certification expired, or should he have been allowed time for renewal process to be completed? Under property interest employment is an individual's legal right to continued employment granted by tenure or contract provisions. This means that an employee cannot be terminated without due process, including notice and opportunity to be heard. Cleveland Board of Education versus London Mill of 1985, property interest employment must receive due process before termination. To determine property employment, 1. Does the employee have tenure or contract rights and expectation of continued employment? 2. Do state laws and district policies grant protections? 3. Does termination requirement cause a hearing according to due process job protections? If an employee has property employment, termination without proper notice or hearing can violate the 14th Amendment's due process clause. So question number 1, was Mr. Myers' 14th Amendment rights violated? In this scenario, yes, this is a potential violation for Mr. Myers' legitimate property interest in his job under Connecticut tenure laws. The denial of due process, he was not given a post-termination hearing, although his union requested one in writing. He has a legal right to be heard. Legal authority of Cleveland Board of Education versus London Mill, 1985. Contradictory state agency communication identified in the Connecticut Department of Education on October 31st of 2013, email stated his certification was still under consideration. This may indicate that the district acted prematurely, and this was identified in a notice that he provided, an email. Was this retaliation for the DCF investigation? Mr. Myers' claims for possible retaliation can be supported by the timing of his termination, having been pursued after the DCF findings were substantiated. In addition, the potential termination letter received on September 12th of 2013 shows the district already planned to terminate him before his certification expired. Another factor to be considered is how the district has handled similar situations regarding extensions for certification issues. If they have, but he was not, it could be considered discriminatory treatment. And our final question 3. Mr. Myers was suing not only for the district, but the superintendent, the principal, the head of district's certification department. Can individuals be held personally liable? Under qualified immunity, it protects officials from personal liability unless they violated a clearly established constitutional right. Under Harlow v. Fitzgerald, 1982. A school district can be held liable if they wrongfully denied Mr. Myers' due process and it's proven. District officials can be held personally liable if individuals have been personally involved in retaliation and/or it's proven they knowingly violated Mr. Myers' due process rights. In this case, the termination appears procedurally improper and potentially retaliatory. The court would rule his due process rights were violated and the district would be held liable. The failure to provide due process hearings for a tenured teacher supports his claim for wrongful termination, a Fourth Amendment right of due process. Mr. Myers has property employment rights as a certified teacher of Cleveland, the Board of Education v. London Mill, 1985. Termination without proper notice or hearing violates his 14th Amendment right to due process, and it would be my recommendation to reinstate Mr. Myers and award him back pay or other compensation. Thank you so much, and that concludes my post. Have a good day.